Hello, my name is Barry Stanton. I'm the managing partner at Boyce Turner, and I've also practiced as an employment lawyer for the past 25 years. In that time, I have seen the growing importance of a knowledge of European and international employment law. In this series, I am talking to my European colleagues with whom I have worked on numerous projects about 5 things we should know about employment law in their country. Today I'm joined by Emanuele Licciardi, who is a partner at the Italian law firm Mori Rossetti in Milan. Emanuele and I have worked together for a number of years on a range of projects for a wide array of clients. Emanuele, it's very good to see you again.
Good to see you too, Barry.
We've talked over the years, Emanuele, about a number of issues which are of interest to clients in Italy. And I wanted to touch on a couple of those points. The first one being workplace investigations and what your advice is to employers around that sort of particular process.
Well, in Italy, workplace investigation is mainly led by the worker statute. It's a law that is already more than 50 because it was published in 1970. And it's a statute that somehow encompasses all the control that the employer can do on employees' activity, both on a physical basis or remotely, and also provides for the rules for the disciplinary proceedings. So this is basically the foundation for the workplace investigation. However, it's not the only rule that set of rules that the employer has to meet when it starts a workplace investigation, because in the years, of course, have other aspects have been added in with the data privacy policies and rules, and also with the whistleblowing directive that has been implemented in Italy. So what the employer has to bear in mind when it starts this kind of process is, first of all, that it's crucial to remember that the purpose here is just to gather information and not to start to initiate a disciplinary action at this stage.
Emanuele, just wanted to ask, in terms of an investigation, I'm assuming in Italy, it's very similar to the UK, where the investigation should be neutral. So it's there to find out the facts and not to prove someone's guilt. And I think and if that's correct, that's a very important point, isn't it?
That is correct. That's the point, because if the employer once carries out the investigation already, starts arguing some specific point, the first claim the employee can have is saying that the whole investigation should be considered null and void, because that was meant only to gather facts and information, not to have any specific fact already reported to the employee as a misconduct. So that's the first point, to be very cautious when you start this kind of investigation, because otherwise you risk to impair the whole process so that you cannot discipline the employee for that fact. Then what we can also say is the role of the witnesses that can be heard during this investigation. Of course, the employer has to prevent any kind of retaliation and safeguard those employees from any act of other employees that are connected to this investigation. And of course, the first step to do here is guaranteeing anonymity of these witnesses, unless, of course, there is some kind of judicial hearing, there is a proceeding that requires the employer to share the name of the witnesses. And what is also interesting in this point here is coming to the controls that the employer can do with the employee, either remote or physically, is that both they are highly regulated. So either the employer has a collective agreement with the unions, or the work council, or he has to go through a specific process of authorization with the local labor inspectorate. So basically, the employer is not allowed to do his own investigation in terms of remote control or control on the employees without this kind of preliminary requirements.
That's very interesting and very helpful. Thank you. And then investigations presumably looking at conduct. But also a big part played in the management of employees is performance management when employees are not performing well. And again, is there specific legislation, specific laws around that in Italy?
The point is that there is no specific legislation around it. So there is no specific dismissal for poor performance reason in Italy. then the poor performance management is still seen, according to the case law, as a disciplinary case. So we go again in the path we have already highlighted, so the worker statute and the rules provided by the worker statute. And so any poor performance should be treated as a case of non-diligent performance of the work by the employee. So basically, the burden of the proof here is on the employer that not only has to give evidence of the poor performance by itself, but also that this performance has been the consequence of a non-diligent behavior of the employee. And the employer should also be able to prove that there is no other external reason that may have impacted on the employee performance, maybe even at the organization of the employer or a trend in the market that could have been caused the actual performance of the employee.
That sounds like quite a high burden of proof for the employer to meet.
It actually is. And this reason why here in Italy, this is a kind of solution that is very seldom used, only when you have, of course, very evident cases in which the employee, compared to other employees that have the same role and with the same tasks, results that are very distant, very far from the expected results and from the results that have been achieved by the other colleagues.
If one's following the performance management process, is there a time frame in which one could performance manage somebody out of a business, or is it very quick?
It's not actually very quick, because since this is not a case that has been ruled, of course, what we need to have to dismiss an employee is a serious breach of contract. So we need to prove that that specific non-diligent behavior is so serious to be sufficient to justify a termination. So basically, either you have a really enormous non-diligent behavior and you are sure, of course, of the other items we are talking about, or you need to have multiple disciplinary proceedings that altogether can be summoned, saying that the overall performance of the employee has been not only poor, but also was not diligent overall. So in our experience, this is something that may take a long time. Usually it's a process that may take months to arrive to a certain point where we can say the threshold to have met the burden of proof is there.
Okay. And so in a case of poor performance, is an employer better placed to try and find some sort of amicable solution?
That could be one of the outcome that we have, of course. It's always tricky, of course, starting to negotiate with the employee in this kind of situation, because it can always argue that there is a sort of duress in the negotiation, or that if the employee is eventually terminated, that is for a retaliation because the employee did not agree to find an amicable solution. But of course, that could be one of the solutions. The other one is to check if in that specific situation, there could be also an organizational reason to terminate the employment. So you have a redundancy. Of course, then you need to be sure that you are still meeting, all the requirements you have for the redundancy case on the other side.
Yes, and I suppose that's easy if it's an employee in a unique position, but much more difficult if you've got one employee among several doing a similar job.
We do have a comparison duty when you have employee in the same pool of tasks and of kind of skills. We also have the so-called repêchage duty. So basically, for employees that are not executives in the medium size and big companies, you still need to offer employee any vacant position, of course, that are aligned to their tasks before making them redundant.
Yes, we all have similar problems by the sound of it.
Just to have a very short answer to your last question. Yes, you have other paths, but not always those paths are really simpler than the one you started.
Okay, thank you. The COVID crisis raised an interesting issue in Italy, as I understand it, which is relating to the delocalization of businesses and the Italian government taking steps to prevent or tried to slow down the movement of business away from Italy. I wonder, Manuel, if you could just talk through that a little bit, because obviously it's still relevant today.
Sure. We did have some specific pieces of legislation that were approved during 2021 and 2022. Basically, they were a reaction to the first experience that we had after the crisis on an economic level, of course, because we had a few big global investors present in Italy at the time that started to move delocalized assets to other countries, mainly, of course, to other European countries that have a lower cost of labor, for sure. So what the government did at that time was implementing new legislation that mainly made more costly for them to transfer their businesses outside of Italy. This was mainly related to contribution, financing, and any other kind of support they had received in the past years from the Italian government on other public funds, so that we're going to lose this kind of finance if they were to move. And also for what interests employment lawyers and employers in particular, they have enacted also a specific path that medium-sized and big-sized companies have to implement in case of delocalization. So the threshold here is companies with at least 250 employees in the years preceding the time which they decide to delocalize, and they should decide to shut down or to terminate at least 50 employees. If you are in this kind of scenario, then you have a sort of aggravated path for the negotiation that you should have anyways with the unions, since in this case, before even starting the usual procedure, mass dismissal, that procedure can last up to 75 days. Then you have to notify this decision to move the business 90 days before starting the mass dismissal procedure to the Ministry of Labor, to the Ministry of Economic Development, and to the trade unions. And then in the next 60 days, you have to draft a plan that aims to somehow reducing the impact that this decision can have on the occupational level. So as you can see, it is already a process that adds up to the usual one, that makes longer the proceeding to arrive to the actual termination of the employment relationships. And of course, it also has the effect of raising the potential claims and litigation related to these processes. Anyways, if at the end of this proceeding, the employer do not find any specific agreement with the institution or with the unions, the sort of contribution that an employer has to pay related to dismissals in Italy is raised for this specific reason.
A question that always interests me here in these situations is if one's moving part of a business, whether that would attract any interest under the Acquired Rights Directive in Italy. If let's say you're moving the business from perhaps Italy to Albania.
It actually does, of course. I would say that employees in Italy would, of course, ask for the application of what is the implementation of that directive in Italy in these cases. But my experience is that is more a negotiational point. So in many cases that we have managed for clients of international transfer of business, I had basically no cases of employees really willing to relocate to another state. That was more an actual issue to govern. And maybe sometimes it has also determined that a change of strategy also in managing the relation with the unions. Because, of course, if you, for instance, try to apply strictly mass termination procedure here because you think that no one of the employees will go to the other country, will not relocate, even if no one of them really wanted to go to relocate, they will use that specific aspect as, a technical point to make their termination null and void. So what you really need to do in this case is actually treating this case as it is, so as an international transfer of business, and applying those directives. So that would mean that, for instance, the Italian employee going to Albania should receive all the treatment he would have been receiving in Italy if the process would have been totally managed in Italy, knowing that it's very likely that when you will go negotiating with the unions, you will end up thinking about a termination process.
I concur with that view. That's what happens in the UK as well. Okay. Another topic we've discussed over the years is employers of record, and I know you have some views on that. And can you just talk about the Italian view of the EOR regime?
Yeah, I think the plain answer to this question would be that employers of record not operate in Italy. Of course, this is a sort of blunt answer, but the thing here is that the lease of employees in Italy is a regulated activity. So any operator that wants to lease employees to another entity here has to go through a specific authorization process, and to gain a license is provided by the Ministry of Labor. So what we have experienced several times in the last few years is that none of the main operators that we have known really have carried out this kind of process of authorization. So they basically reply their business model they have in other countries where I assume is fully legal, here in Italy where they would need to have that kind of license. Of course, this will cause and has caused many headaches to their clients, because of course here in Italy, when an entity that is not licensed, at least personnel, not only that entity goes to face sanction from the authorities in Italy, but also the employer that actually uses the performance of the employee is sanctioned by the authorities, and also the employees can claim and is entitled to be acknowledged as an employee of that specific employer, the one that is uses this activity. So we usually suggest our clients other models that are in line with the rules here in Italy, with the practice here in Italy, that mainly depend on the needs that the client has. If the client wants just to have a sort of spot here in the country because they need to do development and research, or they need a technical support for activity that actually they manage from abroad, then could be sufficient just to hire the employee with a foreign entity and appoint in Italy a social security representative who will pay the social security contribution on behalf of the company. Instead, if they want to develop the market here, to do commercial activity, to have clients directly here in Italy, it could be wiser just to incorporate a small company, even a small limited liability company, so that also all the tax aspect will be clear to the authorities and the employment activity will be way simpler to manage.
That's very helpful. Thank you. And finally, coming on to another favourite topic of employment lawyers and a bane for employers, non-competition covenants. And I know there's various countries are talking about legislation about non-competition. And I was just wondering what the position is in Italy.
They are enforceable. We have actually a quite strict legislation about non-compete that has its grounds in the civil code. And then we have a quite, I would say, impressive number of case decisions that also provide for some guidance in the way to interpret to construe this legislation. Of course, in Italy we do not have the binding precedent principle, but still, of course, if you have the Supreme Court providing some guidelines, they are always useful for the operators. The main points basically is the non-compete agreement has to be drafted in writing. It requires a consideration for the favor of the employee for the non-compete restriction. That is the first point, of course, because the provision of the law does not provide for a specific determination of this consideration, but just said an appropriate consideration. So there's always a balance between this consideration and the other part of the law provision that says that the agreement is valid if the restriction is limited in the scope, in the time and territory. So the scope should be, of course, linked to the activity the employee has carried out for the employer, for the former employer. So a scope that is too wide, it will be wider of the activity the employee has carried out could be considered as unlawful. The time, it depends on the kind of classification of the employee. So for executive, it could be 5 years. For not executive, it's only 3 years. And the territory, again, there is no specific limitation. Could be even worldwide, but the larger is the territory, the higher is the possibility that a court could say that this territory is too wide to be consistent with the other part of the non-compete covenant, so meaning the scope, the time, and the consideration. The overall principle that mainly is seen in this case law is that basically any kind of covenant that restricts the employees from compete with the former employer cannot just annul the possibility of the employee to get a new occupation after he has quit with the former employer. Then, aside of this consideration related to the main part of the agreement, of course, the non-compete agreements still are contracts. So you can have either specific feature and items that you can add to these agreements. For instance, you can have option clause if you want to have the possibility to basically enable the parties to use the non-compete at a certain point during the employment and not from the very beginning. You can have information undertakings if the employer, for instance, wants that the employee communicate if he starts a new employment activity so that he can control if this is in competition or not. And of course, you can have clause for liquidated damages that will help the employer to act in case of breach of the non-compete obligations.
Thank you. Can I just clarify one point on consideration? When you talk about consideration, are you referring to a payment being made for the duration of the non-compete period, or is that consideration being paid at the beginning when they sign the contract?
That is a very interesting point, Barry, because it's part of the discussion that has gone through many years in the case law. Basically, it's a payment that the employer has to pay to the employee has specific consideration for the restriction. So this would imply that it's a payment that is made by the employer at the end of the employment relationship, because, as we said, this should be proportionate to the kind of restriction the employer is imposing. The kind of parameter that the courts have used to see if this is proportionate is the salary of the employee once the employment is terminated. So what the party usually do is to provide for a clause that states that the employer will pay that consideration that will be a percentage of the final salary of the annual salary of the employee at the time of the termination of the employment, or even during the non-competition period, so after the termination of the employment. What many employers have been doing in the years is paying this consideration along the employment relationship. So basically having a portion of the monthly salary or the yearly salary paid as consideration for the non-compete. And just making a very long story short, this has been considered as unlawful because the employee does not have a clear idea of which is the amount of money he will take as a consideration for the for the non-compete restriction at the very beginning of the employment. So what we suggest in this case is when the employer, they do want to have this sort of payment during the employment, is to provide a sort of threshold clause in the agreement saying that in any case, whenever the employment will going to terminate, the payment of the consideration will be equal to that specific percentage of the final salary. And if the employer is not already paid that amount, will top up the amount that has been already paid during employment.
That's interesting. I hadn't really thought about that as a potential way of doing it. Manuele, that's fascinating. Thank you very much. And I'm sure that there'll be a lot of interest in that.
Thank you to you, Barry. It's a pleasure.
Thank you for joining us today. I hope you've enjoyed our conversation. If you want to listen to more episodes in this series, you can follow or subscribe to our podcast. Goodbye.